Good day, Crime Talk aficionados. My name is Scott Reich, and this is Crime Talk. It's November 16th, 2021. First, the jury in the Kyle Rittenhouse case is still out. The Ahmaud Arbery trial continues. Ghislaine Maxwell, her jury trial selection process begins. Do we have a new witness in the Summer Wells case? Well, a couple of stories about some mayors gone wild. Talk about a bad day at work. And an Oklahoma school employee has some trouble. And then our dumb criminal of the day. Let's talk about it. Good day, Crime Talk aficionados. My name is Scott Reich, and this is Crime Talk, the most fact-driven, unbiased, true crime channel. The channel where a practicing criminal defense attorney explains the facts, the procedure, and the law regarding cold cases and current criminal cases. I hope you enjoy. All right, you know the drill. If you haven't hit that subscribe button, please do so. Hit that little bell so you receive notifications of when we go live or put up new content. And as always, please leave me a comment below about the cases we talk about today. And remember, if you can't watch us, you can always listen to this show and past shows by downloading Crime Talk on your favorite podcasting app. Apple, Spotify, iHeart, Android, and Amazon. And don't forget Audible as well. And then finally, we have to support the people that help support Crime Talk. Obviously, we thank all our subscribers, and we thank you for going to crimetalkprep.com. And when you do that now, you're going to be able to claim 3 months of an emergency food kit. In today's world, we've all seen what happens with supply chains and shortages. Literally, things can change by the day. Never thought I would see it happen in our lifetime, for sure. So please go to crimetalkprep.com, get your 3 months of an emergency food kit, and you will get $100 off. Listen, you're going to be happy you did this. This is like insurance. You hope you never need it, but you're glad that it's there if you do. So go get your 3-month emergency food kit, Crime Talk Prep, $100 off. All right, on to the docket. Well, if most people had the TV on this morning, they were waking up to coverage in regards to the Kyle Rittenhouse case. Well, the jury is out. The jury began its deliberations this morning, and Kyle Rittenhouse actually drew the numbers of the 6 jurors from a brown metal tumbler, handing the slips of paper to the bailiff, who then handed them to the judge to read. The 3 men and 3 women whose names were drawn stood as their numbers were read. 6 of the 18 jurors who have heard the case were selected as alternate Tuesday morning, and they must remain in the courthouse while the remaining 12 jurors deliberate. Now, if any of the jurors that were selected were unable to deliberate for any reason, such as poor health, they become sick, something along those lines, then one of the alternates will be asked to step in. Now, while they wait, the alternates will be kept separate from the rest of all the jurors and allowed access to their laptop computers and watch movies provided by the court, but they cannot discuss the case with each other or view any information about the Rittenhouse case. Now, let me just comment on this. Normally, when you have a large number of alternates, usually it's 1 alternate, maybe 2, depending on the length of a case, you know who your presumptive jury is and you know who the alternates are, and it's just the next person in line basically is the juror that would step in if they were the alternates. I can tell you, I have never seen a situation where the defendant spins the tumbler, picks out numbers, and those are the alternate jurors that are selected. Never seen anything like that before. It's apparently something unique up there to Kenosha, Wisconsin. I don't think it violates any rules. That's just the way they do it. And frankly, it's fair. And you can't say it's not fair because, well, the defendant really got to pick his jurors in this particular case, even though he did it without knowing who they were. Normally what happens when you pick the alternate, let's say in a normal jury, you're going to have 13 jurors, 1 is the alternate. The judge will tell you at the pretrial conference, they'll ask your client, pick a number between 1 and 13. Client usually says 7, just the way it is. And that is your alternate. So it's pre-selected. Nobody knows who's going to be in that chair beforehand. similar process, but I've never seen it done before. Well, the prosecutor in this case, Mr. Thomas Binger, he was the prosecutor in the Rittenhouse case. Now, he's caught some heat for pointing the AR-15 directly at the jury with his finger on the trigger. Now, some people are comparing this conduct during the closing argument to the fatal incident on the Rust set. Now, Binger was trying to show the jury how ominous the 18-year-old defendant was on the streets of Kenosha back in August of 2020 by grabbing the firearm in open court and pointing it squarely at 18 people in the jury box. Now, in this demonstration, he violated the first rule of gun safety. Don't point the weapon at any human, being just for show in this particular case. Now, it is what it is. The prosecutor was being dramatic. But as I recall, the prosecutor also made sure that it was a completely safe weapon and it had a band through it. Probably a little over dramatic. And I think the real story from the point of view as it relates to the closing arguments was the fact that the defense didn't object to a lot of the statements that were completely wrong and misstatements of the law. I personally always like to object for several reasons. One, if you don't object, that issue is waived on appeal. But two, you can say, Judge, it misstates the facts, misstates the law. And the judge will say, hey, it's up to the jurors or they've received their instructions. But at least you can highlight the fact that the prosecutor has misstated the law. When he specifically said he was giving up his rights when he went there with a gun, and no, he didn't. No, he didn't. And the law just doesn't read the way the prosecutor wanted it to. But, we'll see. And one thing I have stopped doing, and even on my own cases, you just never know, is predicting what a jury will do. Now, if the jury comes back, we will try to bring it to you live, and I will try to be there when we go live to have some comments on it. We're watching it closely. I don't know. It's 2:30 as of this point in Wisconsin. We'll see if they have something today, but I think it's going to go in tomorrow. But like I said, when it comes to juries, you never know. Now, the next big case that's still going on is the Ahmaud Arbery case. And the defense was moving for a mistrial because of black pastors coming into the courtroom. And I said yesterday, this was one of the dumbest motions that the defense could have made. Seriously. It is a open courtroom. Just like you have a right to an attorney, you have a right to an open and public trial. That pesky Sixth Amendment. Anyone who can go and sit and watch and observe a trial can do so. It doesn't matter who they are, whether you like them, whether you dislike them, what race, creed, nationality, it doesn't matter. Anybody can walk into any courtroom as long as there's space, sit down and watch. I think the arguments being made by Mr. Roddy Bryant's attorneys, Mr. William Roddy Bryant's attorneys, is just ignorant and not good for him. Now, fortunately, the jury doesn't see this spectacle, and hopefully they don't hear about it, but that is just basic law 101. You can't exclude people from the courtroom because you think they're somehow going to intimidate their case. If they're a witness, they cannot be in the courtroom. If they're causing a disturbance, they can't be in the courtroom. But if you're sitting there observing, you have just as much right as anyone to be there to watch a trial. Cases get reversed when people get excluded from the courtroom. You just don't do it. Judges know better as well. That's why the motion was denied. Well, the forensic pathologist who examined Mr. Arbery's body said that he was still standing after being wounded 3 times because he had a fight or flight response, even though the bullet hit the armpit and was enough to kill him. That's right. The Georgia medical examiner, Dr. Edmund Donahue, walked the court through some pretty graphic images that he took of Arbery's body during the post-mortem exam. Now, at the trial, Donahue said that Arbery's cause of death was multiple shotgun wounds. However, he added the shot that struck Arbery's left chest and armpit alone was lethal enough to kill the man. The medical examiner explained that if the 25-year-old had only been shot in his upper armpit, law enforcement and paramedics would not have been able to save his life. Now, the medical examiner also said that the young man's left arm was paralyzed as he fought back against the accused shooter, Travis McMichael. The medical examiner said, when you run into a situation that is that stressful or that you are afraid or is going to cause anxiety, your body and the brain will correlate a fight or flight response. As soon as he realizes there was a threatening situation, that response would start. Now, the medical examiner said that Arbery's was still standing after being shot several times because he entered the fight or flight mode. Now, Mr. Arbery's mother, Wanda Cooper Jones, hung her head as the jury was shown graphic post-mortem images of the son's injuries. The first shot at close range tore through an artery in Arbery's right wrist and punched a gaping hole in the center of his chest. Now, the second shot missed entirely, while the third shot, fired at the point-blank range, ripped through a major artery and vein near his left armpit and fractured bones in his shoulder and upper arm. The jury saw close-up photos of the injuries, which included several large abrasions to Arbery's face from when he fell face down on the street following the third gunshot. Now, photos of his clothing showed his t-shirt stained entirely red. Cell phone video of the shooting shows it had been white. Now, a graphic video of the shooting of the unarmed Arbery obviously went viral on social media, prompting the case to be transferred to the state police and charges being filed. The video and weapon were presented in court Monday as well. Now, during the testimony of how the 12-gauge shotgun was used to kill Mr. Arbery, Georgia Bureau of Investigation agent Brian Leopard alleged it was fired a few inches away from Mr. Arbery. The crime scene analyst also demonstrated how to load and fire the weapon, noting that a lever has to be removed to fire the gun. Why is that important? It shows intent, ladies and gentlemen. Now, just briefly on this. If there's one thing in life that I have come to know and realize is that when I die, I don't want an autopsy. I know you're dead. You're nothing but just bones and some flesh. But if you've ever seen an autopsy, if you've ever seen photos, it's somewhat disturbing. And a lot of people see the first ones of an autopsy of a real person at a jury trial, and it can be somewhat traumatic. Now, the judge has a duty to make sure that the photos that are shown are no greater than reasonably necessary to let the prosecution prove their case. They can't be overly graphic. But as one judge told me, hey, it's a homicide trial. So it can be somewhat shocking indeed. But an autopsy, just don't do one on me. That's all I have to say. Okay? All right. Next on the docket, another big case that we've all been waiting to get started. That's right. Ghislaine Maxwell, the British-born socialite, will get her first sight of potential jurors in whose hands her fate will lie as they are asked questions to determine whether they are qualified to hear the case. Now, Maxwell, who's pled not guilty to all charges, is accused of grooming and trafficking young girls to be allegedly abused by that guy named Jeff between 1994 and 2004. Ghislaine's family and the alleged victims have both been invited to attend the selection process. Now, in an interview with the Daily Mail, Ghislaine Maxwell stated that she's terrified the overwhelming negative coverage will poison her jury pool and affect the outcome of the trial, despite the evidence which she feels quite confident will prove that she is innocent. And she looks forward to having her day in court to prove that she played no part in that guy named Jeff's crime. Now remember, she doesn't have to prove herself innocent. The prosecutor has to prove her guilty. Ms. Maxwell says that she is absolutely innocent. Now, the potential jurors will get a first chance to see Maxwell in person before they could be hearing the case at length over the next 6 weeks. The court has scheduled selection to last until Friday, suggesting it may be sometime before the final 12 jurors and 6 backup alternate jurors are picked from a pool of some 600 candidates. Over those 3 days, potential jurors will be asked a series of questions aimed at identifying whether they may hold personal biases which rule them out as being able to give an impartial verdict. Opening statements have been scheduled to begin November 29th. meaning it will be some weeks before the prosecution will begin to present their case. All right, next on the docket. Is there a new witness in the Summer Wells case? Well, a woman has claimed that she heard a scream shortly before 5-year-old Summer Wells disappeared 5 months ago. Jody Sue Brown said that she and her children heard a scream approximately a half hour before Summer's parents began looking for the young girl. Summer went missing from her home on June 15th of this year in Hawkins County, Tennessee. Her parents believe that Summer was abducted, and police have not been able to come up with any suspects or leads at this point. Jody Sue said that she was in the neighborhood with her 19-year-old and 14-year-old child listening for noises due to property things, end quote, that happened the day prior. Jody Sue said, "We were kind of hyper alert because of property things that happened the day before, so we were listening for noise. Everyone was kind of quiet." Jody Sue said she noted a car drive up the Wells driveway, which she claimed struck her wrong. She said she then heard a car door slam, which she did not think was suspect at the time. Jody Sue said shortly after noticing the car, she heard a scream and became concerned. "It stopped all three of us cold," she says. Her son described the sound as a shrill, almost animalistic scream. Jody Sue said she and her son went to investigate the scream but did not find anything, but soon saw Summer's parents, Dawn and Candace, searching for Summer. Now, Jody Sue said, and at this point, I started hearing them holler for Summer. By the third, I knew something was wrong, and then my brain immediately went, scream earlier, this, uh-oh. By this point, she said she dropped her purse and yelled to Candace that she was going to help them search for Summer. So we have to assume that Jody Sue has given this information to the police, but now she's coming forward to talk to the press. Assuming she's gone to the police, which I hope she would have. Obviously, she did not provide a description or anything that would help lead to the discovery of young Summer Wells. We'll just have to wait and see. We're just going to have to wait. And as we all know, with these cold cases, every day that goes by decreases the chances that someone is actually going to be found. Next on the docket, some mayors gone wild. The first, a 22-year-old mayor of Goddard, Kansas, was arrested over the weekend on suspicion of driving under the influence of alcohol or drugs and driving improperly on a laned roadway. Hunter Kobe Larkin, he's a mayor there, bonded out of the custody of the Sedgwick County Sheriff's Office after being arrested on Saturday. The mayor was nabbed by the Kansas Highway Patrol near Kellogg Drive and Tyler Road in West Wichita. Mayor Larkin failed to maintain a single lane of traffic and was pulled over at 1:26 a.m. and was booked at 3:04 a.m. Larkin became mayor by appointment in August of 2020 after the former mayor, Jamie Blubaugh, resigned due to his own brush with the law. Former Mayor Blubaugh and his wife were accused of counterfeiting tickets to a Sedgwick County zoo event. Larkin filed papers to run for the Kansas House of Representatives in August. His campaign website proudly states that he has been able to achieve goals that no other governing body member has been able to accomplish in Goddard. Larkin's website also says he's learned his skills by working in the oil and real estate industry for 4 years, where time, relationships, and communication are so vital. Now, the city of Goddard's own website says Larkin was formerly the president of the city council. And finally, Larkin's campaign website lists his accomplishments as having included lower water and sewer rates, 6 new residential developments, a more transparent and honest government, and other infrastructure investments aimed at attracting more commercial development. No court date has been set, and Mr. Larkin is unclear if a prosecution against Mr. Larkin has, in fact, commenced. Oh, I'm sure that it will. And now Mr. Larkin will be able to add to his repertoire of accomplishments, hopefully successfully completed DUI probation. Better sign up for those alcohol classes. Get ready to start walking, Mr. Larkin. And don't forget to sign up for your Mothers Against Drunk Driving panel as well. Next on our Mayor's Gone Wild segment today, A Maryland mayor is facing criminal charges after he allegedly distributed images of so-called revenge in multiple Reddit forums. Andrew Bradshaw, the mayor of Cambridge, Maryland, is charged with 50 counts of violating a Maryland law that prohibits distribution of sexually explicit materials without consent or in a way that is intended to harass. Now, according to the complaint, Bradshaw allegedly distributed sexually explicit images at least 50 times between early and late May. He allegedly posted the pictures in Reddit forums with titles such as "humiliating comments," "degrade this pig," and degraded captions. Several of the images were accompanied by racist captions as well. All were posted with sexually explicit captions, many of them degrading. Each violation of the Maryland law is a misdemeanor offense, and the woman in the pictures was previously romantically involved with Bradshaw. She told police that she had shared the pictures with Bradshaw, but that he posted them to Reddit without her knowledge or consent. Now, according to the complaint, investigators traced the accounts that posted the photos to Bradshaw's home address. Bradshaw faces up to 2 years in jail and a $5,000 fine for each count. Now, Bradshaw, who's 32, is the youngest ever mayor of Cambridge. He took office in January 2021, according to his bio in the Cambridge City website. Bradshaw is a lifelong resident in the Cambridge area, and before becoming mayor, he worked in his family's towing company and waste disposal business. Bradshaw is still mayor. The city's commissioner will be meeting with the city attorney about Bradshaw to examine the city charter and the code to see what options exist and if any actions need to be taken. Now, Bradshaw made his first court appearance just yesterday and was released on his own recognizance bond. What can be said about this? You know, first, there's an old saying that you get the government that you deserve. And as I get older, I'd like to think that I have a little more better judgment than I did when I was, say, 21 and 22 and, being the youngest of whatever. And the reason is you've gone through life, you have life experiences, and hopefully you get all that stupidity out of you. You really don't want people in charge that, don't have a whole lot of real life experience. Now, obviously, we'll give these two mayors the presumption of innocence, which they deserve, but this is childish stuff that you would hope that people in public office wouldn't be doing. We've said this before, regardless of what a party affiliation they have. Listen, if you're in public office, you're a public servant. You're held to a higher standard. These people, obviously they have to go through the process, given the presumption of innocence, due process, etc. But I think the honorable thing would be that they would resign. But hey, that's just me. What do I know? Okay, let's talk about somebody having a really bad day at work. An ambulance driver in Georgia killed a dialysis patient after crashing the vehicle while under the influence. Now, on Friday night, ambulance driver Kevin T. McCorvey was arrested and charged with driving under the influence, first-degree homicide by vehicle, failure to maintain lane, and possession of an open container after the crash. Now, McCorvey, 34, had been driving an EMS ambulance on West Campbellton Street in Fairburn around 7:25 p.m. when he veered off the west shoulder of the roadway, overturning the vehicle into a ditch. The driver had been transporting Wilton Thomas Jr., 66, who was found to be unrestrained in the ambulance and suffered fatal injuries. McCorvey and a second person who was working in the ambulance were stopped by a Fairburn police officer who tried to leave the scene in an Uber. Calling Georgia State Police troopers for backup, the ambulance drivers failed a sobriety test and admitting to smoking marijuana, taking Adderall, and drinking a beer while driving. Now, on Monday, Mr. McCorvey was denied bond after making a first appearance in the Fulton County Superior Court, where he was assigned an attorney. Now, the police chief said Tuesday that the investigation into the crash has been handed over to the Georgia State Police, and the blood samples that were taken and the results from the toxicology report are still pending. That almost makes it from the bad day column to the dumb criminal column. What's really sad is that the gentleman in the back, unless he was partaking of the party favors, he is just an innocent victim, which is obviously a tragedy indeed. Well, let's talk about somebody else who was having a real bad day. A 45-year-old middle school employee has been charged with the alleged forcible sodomy of a 14-year-old boy in Oklahoma. Now, a statement from the Oklahoma County Sheriff's Office accuses Shannon Heslip of forcing the victim to engage in acts in the garage of her Nakoma Park residence. And during the investigation, authorities allegedly discovered the illicit contact started last month, and they also discovered very racy messages sent to the teenager. Investigators further alleged Miss Heslip also sent naked photos of herself to the boy via Snapchat. Now, Heslip took the boy for ice cream prior to the alleged incident. Heslip posted a $50,000 bond for her release. It was unclear if Heslip had entered a plea on the charge or had a lawyer as of date. Of course, she's entered a not guilty plea, or one hasn't taken place yet. But the reality of it is, ladies and gentlemen, you just can't make this stuff up. And I just don't get, we seem to see more and more female teachers wanting to hang out with young boys. And they're still boys. And it's a position of trust, which just bad news. You just don't do it. Use some common sense. Go be mayor or something, okay? Because 45 and you're still making those immature, stupid mistakes, it's not a mistake. It's a willing, knowingly act. No, it's not a mistake. It's a willful, knowingly completed act on her part. We'll give her the presumption of innocence, but she better hire a lawyer. And finally, our dumb criminal of the day. CrimeTalk's dumb criminal of the day. A pizza-eating suspect responsible for a pair of car break-ins was caught after deputies followed an unusual trail of evidence in Florida. Dewey J. Smith was arrested on Wednesday after being caught carrying victims' credit cards and IDs, and deputies responded to the break-in calls and noticed marinara sauce was on the inside handle of the driver's door. There was also an empty pizza box at the scene of another break-in. Neighbors reported Smith going through their garbage earlier that night and taking a Little Caesars pizza box. When Smith was caught walking on Twin Oaks Street with the victim's cards in his hands, he reportedly said, "You caught me red-handed."